I like your hair, Madam Chair.
Oh, thank you so much. What a great way to start. I
Yeah.
am Delegate Janelle Wilkins, and this is a meeting, one of our final meetings of the Election Law Subcommittee. The date is April 1st, 2025. No April Fools, but we do have amazing bills that we are going to discuss today. We're taking up 3 bills. The first bill that we will take up is House Bill 93, Senate Bill 945, absentee ballots, notice to request application. And this bill requires that each local board of elections shares information about requesting absentee ballots with the sample ballots that are mailed. So as we know, all of our districts, all of our counties pretty much send out and are required to send out. They're called specimen ballots in election law, but I think we all call them sample ballots, and those are mailed out. And we want to make sure, and what this bill requires is that the information around requesting an absentee ballot is included in those mailings. And those sample ballots are required in current law to be mailed at least 1 week before the first day of early voting. So it doesn't make any changes to those requirements. Stan, is there anything that I missed or anything you want to add?
No, I just wanted to clarify the bill numbers are Senate Bill 93 and House Bill 201.
Oh, 201. Whoops, thank you.
No problem. And also that the bill also says that the information about how to request a mail-in ballot application would be included in other mailings as well to eligible voters and registered voters. So that might include the state already identifies pre-qualified voters through the Motor Vehicle Administration. And so a notice about how to request a mail-in ballot application would also be sent to them. That's it.
Got it. And Mr. Demarinis, to unpack this a teeny bit further, if you can share with us a little bit how we would expect, do we think this would be a QR code? Is just an extra sentence or extra page in the already existing sample ballot?
Sure. Yeah, so I would say that it would be both those. It would be a link to the website for people to or to type in on their computer, or a QR code so that they can then just access it online immediately. So that's kind of it's to request it through the online portals for the absentee ballot application. So with these notices.
And for further information and for the group, this bill came in actually requiring that the absentee ballot information go out as it did in previous that it actually be mailed out as it has been in previous elections. So what we just referred to is how the bill is as amended. It would just require that some information be provided within the sample ballot mailing and then the other additions and clarifications that Stan made. So on the amendments, I would like to entertain a motion.
Move favorable.
Second.
Any discussion on the amendments? Seeing none, all those in favor of we're going to take these 2 bills together, by the way, unless there are any objections. So we're on Senate Bill 93 and House Bill 201. Any discussion on it's been moved, properly seconded, discussion. All those in favor of Senate Bill 93 and House Bill 201 amendments, please raise your hand or say aye. Any opposed? Delegate Miller is opposed. All right, on the bill as amended.
Move favorable.
Second.
Okay. Any further discussion on the bill as amended? Seeing none, on the 2 bills, Senate Bill 93 and House Bill 201. All those in favor, say aye, raise your hand. Any opposed? Delegate Miller opposed. All right, Senate Bill 93 and House Bill 201 move favorably as amended from the subcommittee. We will, I believe, be voting these potentially today. Is that right, Stan?
No, they need to
Or
be
is
on
it
full
later?
committee for tomorrow.
Okay, alrighty, likely tomorrow. Thank you.
Mhm.
All right, moving on to the next bill. We are looking at the deep fake issue that we've discussed several times. I want to make sure I have my bill numbers right. So Stan, you can jump in if I'm getting these wrong. But this is Delegate Feldmark's bill, House Bill 525 and Senate Bill 361. Election law, I'm getting the nod from Stan, election law influencing a voter by dissemination of a deep fake. That by amendment, we've changed the title of the bill and also the content of this bill. So let's definitely discuss carefully. And everyone has the reprint in their email, so feel free to take a look at that. As everyone knows, the bill came in focused in on fraud. And we are focusing in on deepfakes. And the way that the bill would work now is that it would prohibit a person from influencing or attempting to influence a voter's decision on whether or not to cast a vote for a particular candidate or ballot issue by disseminating a deep fake. So this is about whether or not to cast a vote, period, or for a particular candidate or ballot issue by using a deep fake, and this is with fraudulent intent. A deep fake, the definition in the bill now, means an image, an audio recording, or a video recording that has been intentionally created or manipulated with the use of generative artificial intelligence or other digital technology to create a realistic but false depiction of a person, which an ordinary person would conclude is an actual visual or audio representation of the person depicted. We do not include news media. They're exempted, and satire and parody is exempted as well. The bill also defines what fraudulent intent is. And so that is a general overview. I'm going to ask Stan to add in any additional details on this.
Sure, I only have one thing to add, which is that the language in subsection E also exempts basically persons who provide services that might be used by others to disseminate a deep fake. So if your services or facilities are used to disseminate a deep fake, then you're not going to be liable under this bill. And that would include social media platforms, internet service providers, various radio and television broadcasting stations, and so forth.
Thank you, Stan. On the amendments, Delegate Fair, and I see your hand up. Any discussion?
Yeah, just understanding that this is an incredibly sticky situation. One of the on the amendment, it outlines that it doesn't apply to satire or parody. I'm just curious, Stan, is there any way that we can define the difference between, I mean, not literally in the bill, but is there a way legally that they define the difference between satire, parody, and what is being disseminated as a deepfake?
I don't think so. I think it's a very fact-specific question that would have to be the subject of litigation. And so I think a court would look at the facts in detail to determine whether it was satire or parody. But it's clear that satire and parody are constitutionally protected.
Yeah, absolutely. Thank you so much. Thank you, Madam Chair.
Thank you for that great question. Yes, there are definitely some free speech pieces, and we made sure we included satire and exempted satire and parody for those reasons. I had asked the same question, so thank you for that, Delegate Fair. Delegate Miller.
Yes, thank you, Madam Chair. Along the lines of they can't be punished for disseminating it, but is there any provision if they are asked to stop and they keep like either the news media itself or a platform where you're saying, hey, this is, a situation that's not allowed, and they keep disseminating the artificial image. Is there any protection or provision for that then they have to take it down? Like they can't keep doing it once they know it's wrong.
Great question. To clarify, you're asking specifically if it's news media or social media or someone that's asked to take it down.
Yes, if we ask them to take it down and they keep, because it's illegal here in Maryland, and they keep doing it, then what?
Very, very good question. We had talked a bit about that, but I'll let Stan respond.
Yeah, so there's no injunction authority in this bill, but you know, an individual who might be harmed by a deep fake would have the ability to go to court as a civil case, a defamation case, and there is the ability to get an injunction in court for that under the current law and under our current Maryland rules. But that would be against the person who was actually disseminating the deep fake. I do not believe that would be directed at the platform. I believe the platforms under federal law are protected, that they are not liable for the content that's distributed by others using their facilities. I mean, so this bill is really just mirroring the federal rules in that regard.
Thank you.
Thank you, Delegate Miller. How about we adopt the amendments, then we can have any further discussion. I'll entertain a motion.
Move favorable.
Second.
It's been moved and properly seconded. The amendments, we're going to do both bills again to House Bill 525 and Senate Bill 361. Any further discussion on the amendments? All right, all those in favor of the amendments to HB 525 and Senate Bill 361, please raise your hand or say aye. Anyone opposed? Okay, the ayes have it. We are now on the bill as amended, HB 525 and SB 361.
Move favorable.
Second.
Great, and if someone can chime in, if they have any further discussion, but seeing none. All those in favor of favorable as amended for House Bill 525 and Senate Bill 361, raise your hand or say aye. Any opposed? Seeing none, these bills move forward favorably as amended to full committee. Okay, one more bill for today, Senate Bill 259, Election Law, Local Boards of Elections, Election Plan Requirements. So for background, several years ago, we made sure that our local boards put forward polling place plans and ballot drop box plans, early voting plans. And this is to help make sure that our residents and also leaders and advocates have a transparent process to know when drop box locations are being determined, when early voting sites and election day sites are being determined, and can have the opportunity to weigh in. So we currently have a very specific process on community engagement around the site selections, and those also have to be sent to SBE for approval. This bill streamlines a bit more and also increases the timeline so that our communities can have a little bit more time to process. It requires that the local boards have to submit the plans to SBE 7 months before the statewide primary. I believe before it was 6 months in the bill. So now a little bit more time of 7 months. And it also consolidates the plan so that there's one election plan instead of saying polling place plan, ballot drop box plan, early voting plan, just having an overall election plan, which I think makes a lot more sense and will help ourselves and our voters and advocates to follow along a little bit more. There are also a few other both amendments and changes that we have made in this bill. So Stan, if you can talk through the amendments to the bill.
Sure. So basically 3 major amendments. The first requires a local board of elections in the first year after redistricting to submit certain information on it, to submit certain information if its polling place plan will reduce the number of polling places below the level in the immediately preceding general election. So it basically just establishes a special rule in that first year after redistricting that you have to look back to the immediately preceding general election if you're reducing the polling places below that amount then you have to provide some additional information. The amendments also establish procedures for public notice and comment when a local board adopts an election plan. And finally, they require the Attorney General rather than the state administrator to review and approve ballot drop box locations. That's all, Madam
Any-
Vice Chair.
Thank you so much, Stan. Any questions or discussion? I don't see any hands on this one. Delegate Roberts.
Thank you, Madam Chair. I noticed in the bill that it lists out for the following elected officials and it goes from the mayor all the way up to the General Assembly. I was just curious as to why it doesn't also list the governor and the comptroller seats.
For them, is that the part that is notifying individuals about the changes?
Right, it says, right, if the,
Okay.
yeah. mhm.
So that's a good question. So we did this bill a few years, that part is existing from a few years ago. And I
Mhm.
think that what we were thinking is that we want the local community members and the elected officials that really locally represent those areas, that know the precincts, that are, will know the ballot drop box sites to just have the opportunity and the notice
Mhm.
around what the plan is looking like and what their local board of elections is proposing. So I think it was just thinking that we're kind of trying to keep it focused on some of the local representation who
Okay.
probably really know those precincts and ballot drop boxes and locations the best.
Okay, and just curious, why, I mean, about this going from 6 to 7 months, what the reasoning was for that, just to add a little bit more time? I mean,
More time, but I'll ask Mr. Demarinis to respond.
okay,
Yes, so this allows for the local boards to do it at the 7 months, and then it goes to the state board for approval. So that would occur at the 6 month mark. So it's still in the same timeline that we currently have. It allows also if there's any sort of, if the state board does not approve and has to go back to the local boards, for them to come back with a new plan or a new early voting location or polling place plan. So without disruption of any of the calendar. So
Oh.
this extra month allowed for greater flexibility and for rejection as well.
okay, thank you, Madam Chair.
Delegate Fair, then Delegate Miller.
Thank you, Madam Chair. I was checking in, and Mr. Demarinis, if you want to weigh in on this question, or Madam Chair, the change out from the state administrator to the Attorney General. If we could just kind of outline those changes and what the logic was behind having the Attorney General review that. Is that a legal framework kind of decision?
Mr. Ward or Mr. Demarinis on those amendments?
I defer to Jared on this one.
That wasn't necessarily mine. So.
All right, very good. Thank you, Madam Chair.
Thank you, Delegate Fair. Delegate Miller.
Okay, I'm not sure which this one is on, but it's under section D when it talks about the early voting center plan.
Are you on the reprint?
Yeah, I think so. I don't know if I am.
Okay, you can go ahead. Just
that-
if you can explain to us the question, we'll do our best.
Okay, yeah, just as far as with the early voting, if we are taking into the account the public transit portion of it? Okay, so if we're doing that, and you have a situation like, in my county, we have more public transit, of course, in the city versus out in the county. So would that mean, since it's a shall statement in there, would that mean that there's more, you would be more likely to put them in the city versus out in the surrounding county? So is there any way we could put like, where geographically feasible or something along those lines? Because a lot of counties out in our rural areas don't have as far as the mass transit aspect.
Mr. Ward.
Yeah, so I would say that that these are factors that they have to consider. It's not a mandate that obviously that the early voting centers all be accessible to transit. It's just they're factors that they have to use, and then they have to balance those factors because obviously there's different things that weigh different ways. So like the proximity to transit is one factor, but then equitable geographic distribution is another. So they would have to balance that, and then they would, justify that in the plan that they establish, and then the state board would review it, considering the different things they had to balance.
Okay, so they will be looking at both. I was concerned with the shall statement being under that. Thank
Sure.
you.
Yeah, these are factors they'd have to use, but no one of them is an absolute requirement.
Okay, thank you.
Mhm.
All right, I don't see any other hands. I don't believe we've adopted the amendments yet, so I'd like to entertain a motion on the amendments.
Move favorable on them.
Second.
Okay, perfect. It's been moved and seconded, the amendments to SB 259. Any further discussion? All right, seeing none, all those in favor of the amendments to SB 259, raise your hand or say aye. Any opposed? The amendments have been adopted. Senate Bill 259, favorable as amended.
Move favorable.
Second.
All right, it's been moved and properly seconded. Any further discussion? All those in favor of SB 259 as amended, please raise your hand or say aye. Any opposed? SB 259 moves forward favorable as amended. Thank you for the great discussion. Those are our 3 bills for today. We can definitely expect to meet again this week. So for our advocates that are listening and wanting other bills to move, we will